July 19th, 2017. First thing that we need to do is have our quick roll call just to affirm that we are certified for quorum and can do official business today. So we'll just start on the end. Mr. Fitch?
Here.
Mr. Smith, Dr. Smith?
Here.
David Weir here.
Brittany Webb here.
Darrell Gaines here.
Okay. So all 5 board members are present, certified at quorum, and so we're fine there. I don't see any guests out. I think everybody here is staff, correct? Help me out, I think so. Okay, so no other, any other introductions from the support staff and staff here at TDLR?
Delia Luna with the advisory board support team.
Nick Voinis, Chief of Staff.
Mary Winston, Advisory Board Attorney.
Wendy Pello, Assistant General Counsel.
Okay, Stuart, we're going to come up to you, then we'll go down the back.
Stuart Meyer, Health Professional Compliance.
Ken Sharp.
Okay, yes, sir.
Ron Foster, State Prosecutor Enforcement Division.
Deegan Teacher, Director of Licensing. Christine Lai with the Podiatry Board Observing.
Leonard Rivas, Licensing Manager.
Katie Pringle, Education Examination Division.
Stephen Mills, Health Professions Section Manager.
Kim Witt, Education Examination.
Okay, great. Thank you all for being here this morning and bringing in your level of expertise. Next item is approval of our minutes from our meeting in December the 12th of 2016. These minutes were sent to the board prior to this meeting. You've had an opportunity to review those. Is there any additions, deletions that you found in the minutes that we need to address before I call for a motion to approve? Hearing no concerns or additions or deletions, may I call for a motion to approve the minutes as written?
So moved.
Mr. Fitch makes that motion. Do I have a second?
I'll
Second.
second.
Brittany Webb indicates a second on that. Any discussion before I call for the vote? Nothing being noted. All in favor of accepting the minutes as written indicate it by saying aye. Aye. All those opposed, like sign. Our minutes are approved as written. I think the next thing that we need to move, I don't notice anyone here for any public comment. Wasn't notified of anybody signing in, so I don't think that we have anything to address from a public comment standpoint. So I think we're moving into section E, our staff reports, and that will begin with the executive office report.
Mr. Chairman, board members, I'm Nick Voinis of TDLR, and here to bring you the executive staff report. As you all know, TDLR's longtime executive director, Bill Cooch, retired last fall, and Deputy ED Brian Francis was promoted to executive director. And after that, to handle the growing workload at TDLR, Brian hired a deputy executive director and a chief of staff. And we started about 3 days after your last meeting, so we've been here about 7 months now. Our new deputy executive director is Carla James, who came to us from the state controller's office, and she's mainly responsible for operations and regulatory services. And I joined TDLR as chief of staff from UT Austin and handle external services. Want to get into the legislative session a bit. Our focus, as you can imagine, the last few months has been on the Texas legislature, and it's been a busy one, arguably the busiest one that TDLR's had in quite a while. State House and Senate convened in January, and they met through Memorial Day, and they're back for a special session, started yesterday. This session, more than 6,500 total bills were filed, and TDLR staff tracked a total of 341 bills, 130 that were directly related to current TDLR programs, 20 dealt with new or transfer programs, and 191 bills that, if enacted, would have affected agency operations. It was a real team effort. Everyone worked really hard analyzing, monitoring, providing feedback, and resource testimony. We attended 65 hearings before 20 different House and Senate committees, and there was one bill affecting this program that passed and was signed into law by the governor, and that was House Bill 4007 by Representative John Kemple, and it removes barriers, redundancies, impediments for the 13 licensing programs that were transferred to TDLR from DHSS, including this program, the athletic trainers, and that was as a result of Senate Bill 202 that passed during the '84 session. In summary, HB 4007 repeals redundant sections relating to administrative penalties, license denial, criminal penalties. TDLR already had this authority under Chapter 51 of the Occupations Code, and removing duplicative statutes allows TDLR to be more efficient and consistent in its administration of licensing programs. It also removes the requirement for the department to maintain rosters and registries of licenses and applicants. TDLR already provides license information through the TDLR website at no cost. And it repeals the 5-year residency requirement for membership on this board. And this is an unnecessary restriction that limits the number of qualified individuals eligible to serve on your advisory board. The bill passed both houses, and the governor signed the bill on June 15th, and it becomes effective September 1. We now begin our bill implementation period, so everyone's involved in developing rules, communicating to stakeholders, appoint and prep advisory boards, hire additional staff, deal with education, exams, IT programs, and more. So we're heavily involved in that at the moment. You can go to our website, tdlr.texas.gov, to get a full review of what happened during the session, and it's all broken down by program. So just click on the capital picture on the front page, and it'll direct you to that information. Also like at this time just to promote our social media accounts. Please like us on Facebook and follow us on Twitter to keep up with all our news and information. If there's any questions, be glad to answer.
One question, and just kind of moving forward, I mean, this was, this particular legislation was more of a housekeeping, house cleaning legislation that didn't have a major impact. Had we had a bill of significant measure, would there have been more communication or a different line of communication down to us, letting us know that was going on from you guys?
Can I jump in? Mary Winston, Advisory Board Attorney.
Sure.
Yes, in a word. On our different advisory boards for programs that had more impact or bills with more impact during the session, we had members of our board speak, provide testimony for the ledge, and actively participate. You guys were really kind of safe this time. We just needed to clean up a few things, and the legislature did that, and we didn't have to bother you.
Okay, that's fine. I just wanted, it's more or
But
less.
we will.
Okay, okay. I just thought, as
we
things are
count on you
new
guys.
in this
Absolutely.
agency and dealing with us, I just kind of wanted
Oh,
to know
yes.
what the expectation levels from us, what we could expect as that communication,
We
from you
will
guys.
reach
So,
out. We try not to interfere with your schedules, but we, of course, don't have command of when we're called to the Capitol to testify. So whoever's available, we, ask you please, as part of your service for this, to do so.
Okay.
And on several occasions in different boards where there was more impact, we did have that. So, yes.
Okay. Any other questions from any board members?
I think it's important for y'all to know that, if you see legislation that may impact athletic trainers, we want to be kept well aware of it.
Absolutely.
Actually, Mary Winston again, I just saw Jeff Kopus enter the room and try to sneak in here, but he's our communications specialist, and during the whole session, he followed, how many bills?
341.
341 bills. We also, on our website, posted each bill. Jeff is amazing. It's like a search for just a word that may impact what you do, and he's the first line. All of us just kind of jump in, lockstep with him as he does this, but we definitely, you guys just were good this time.
Okay.
But
Well, I think as a board, in an email, if it can just be
Sure.
lack of a better term, an FYI.
Oh,
Hey,
yes.
this bill's out there. This is a housekeeping bill, not any major impact, but just let you know that's coming.
Definitely.
And it's more or less just in case we get contacted. Yeah, we know. We've been, TDLR has made us aware, nothing to be concerned about. And so I think that I would like that communication, just kind of come from you. I mean, we don't have to gather in a board meeting. It can just be through an email, FYI. Hey, just let you guys know.
Trust me.
We can't have discussion on it. We
Yes.
can't, and.
We'll be on it, and Jeff will be
Okay.
like totally on it.
Perfect.
He's wonderful, so thank you, Jeff.
Okay, anything else, board, on this particular? See, you get called out for that. Okay, think we're ready to move to our compliance division report?
Good morning, Stuart Myrick from Compliance Division. It's been an interesting 6 months, been fun 6 months so far. Couple of updates. We will be at SWATA starting tomorrow. Myself and Fanny from Education Examination will be manning a booth. I think this is my 10th year.
Good.
Wow, that's a long time. But we'll be out there to answer questions, do what we do, and get some good stories, hopefully. The section as a whole, we remain focused on maintaining and improving the operation of the several health profession programs, including athletic trainers. We kept tabs on House Bill 4007 as well as other bills that affected the programs within our purview. We continue to be represented on the VERSA improvement team, recommending improvements to our licensing database. And a lot of those improvements are going to be in conjunction with the next 6 programs that will transfer on November 1st from DSHS. Speaking of that, of course, we are continuing to prepare for that transition. The 6 additional programs: massage therapy, sanitarians, code enforcement officers, offender education providers, mold assessors, remediators, and laser hair removal facilities and personnel. Those 6 programs will transfer effective November 1st. Commission will be voting to adopt proposed rules at their meeting next week, on the 28th, and then we will work on those. We'll also have the podiatry board coming over to us, and we'll be part of that, as well as a new program called Behavior Analysts. And so we are currently involved in getting that ramped up and set up. Nick mentioned House Bill 4007. There's several of us, including me, that are on the implementation team, easy for me to say, to implement that bill. And so we'll be working to get those cleanup items and such all ready to go and have that ready when the bill becomes effective on September 1st. Any questions? As always, you know where to find me.
Anything for Stuart? Thank you, sir. Appreciate your report, and we look forward, as a board, and we look forward to having you down at SWATA to, again, continue to make a presence and represent TDLR and our athletic training board. We appreciate that support and time it takes out of your schedules to come down, but I think your presence there, now over 10 years, I think I've heard nothing but great things about having you guys there.
Yeah.
So certainly a great thing. Okay, Education Examination Division.
Chairman Weir, members, everybody, good morning. I'm Fanny Pringle with the Education and Examination Division. And before I get started, I just wanted to let you all know that E&E has completed our transfer relocation from EOT downtown to here at the North Campus. We are on the first floor in the southwest corner, Suite 105W, and please feel free to come by and visit us anytime. Division-wide, we continue to make improvements to our athletic trainer and other Phase 1 programs, the E&E activities, procedures, data management, and communications. We are also immersed in Phase 2 development, planning, and projects, particularly mold remediation and assessor sanitarian, massage therapist, and code enforcement examinations. Also, the offender education provider program planning activities. We're additionally heavily involved in the agency's legislative work groups. I think we have division representation on 8 of 10 work groups. E&E was deeply involved in, or deeply impacted by the new requirements and program changes, and so we wanted to get on the committees, make sure that we are successful in implementing those changes. On the examination side of our division, the Athletic Trainer Examination Review Committee met in April for a couple of days to review the exam. We edited existing question items and approved many new question items, as well as made adjustments to the practical examination administration process. The next practical examination will be December 3rd, and the registration deadline will be November 26th. Also to date, there have been 314 jurisprudence examination completions. On the education side of our division, we've been doing audits since November, and it's based on 10% of the regulated population. And I believe they've completed May's audits and are working to complete June's. Lastly, I am pleased to report that I will be in San Marcos tomorrow and Friday. To echo what Stuart said, we will both be working the TDLR information booth. We'll be answering questions. I'll be passing out candidate information bulletins for the exam, the CIBs, and just generally classing up the joint, so.
Okay, good.
Free of charge.
Well, Stuart needs some help on that sometime, so we appreciate you being there.
You're very welcome. Any questions?
How, I think the May exam was our first level of going the two-step process of being able, getting through the written exam prior to going to the practical. Does that receive well and go okay?
That's not been consistent. We have published, that's been published, and I know that that's the practice been the practice in the past, but we have not finalized our data management system to trigger those eligibilities. So there are people that are still not testing in order, and we did not want to turn anybody away.
Okay.
Because we have not been clear with that. Our eligibility notification system should be in place for the next examination, in which case that will go into effect across the board.
Okay. Yeah, I think as far as in management of staff and things like that for the future, I think that's the, and I know as a board, that's been our desire, that we're going to, move to that direction.
And that will be beneficial to PSI administration-wise as well.
No question. Okay.
Could I ask some questions?
Sure.
About the abysmal pass rate for the written exam?
Fanny Pringle again. Yes, I know it's been, it has been low. I believe part of that is because it is a new exam format, and that's expected. Anytime there's a change to an exam, we expect the pass rate to drop. There are other factors in play, and I think that we need to see a few more cycles to go to be completed before we can make any assessments. I think Chairman Weir, you and I have discussed, as well as Brittany at our ERC, that our plans to have to be able to provide pass rate statistics by university that may be helpful in identifying where, if it is a problem within training. When we do have our ERC meetings, our SMEs have been very diligent and to ensure that all of our examination questions are concise and clear. We've deleted, I think, 9, I think the last session we made edits to, I think, 41 questions and deleted 9 questions. I think we're improving our publications, our CIB publication to provide candidates with a more clear expectation of what, a clear idea of what the expectations are on the exam. And we made improvements to the examination results report to the candidates so they have a better picture of where they're falling short, and they can to provide them better feedback. So we're working on trying to get those numbers up, but we don't want to change, we don't want to dumb down the test. You know, our SMEs are very confident that the exams do reflect a baseline minimum competency. So.
Well, I would challenge you, y'all take care of a number of different specialties or whatever, and do you have any other group where the pass rate is less than 50% on a consistent basis? Because I've been involved with education, the national boards in medical school, board examinations, specialty examinations, and I've never seen a pass rate less than 50%.
We do have a couple of other programs that fall into that category. And again, I don't feel that is a reflection of the examination content. There are programs that do not require training, in which case they don't have this is a personal opinion, that they do not have the tools to pass that exam because we don't require training for some of those programs. However, we're working on getting statistics to see if that is in fact the case. We'll be getting statistics that will correspond to the level of education, to their scores, and we'll have a clearer picture if that is an impact.
Is this data public knowledge?
The exam rate, yes. We don't have it posted for athletic trainers right now because we haven't gone through an entire fiscal year. However, for all our programs on our exam webpage, we do have the pass rates for each license type and level, and some of the, for like our barber cosmetology, you can get pass rates for specific schools, and that's what we would like to do for athletic trainers, so we can see, you know, who's performing and who's not, and if that's a factor.
Another piece of data that you know, David and I have seen before as far as in our relationship with the previous board at DSHS was not only the university pass rates, but also the different methods in which they're coming in on.
Mm-hmm.
So whether they're coming in from an internship candidate or coming in through an accredited, you know, and so those pieces of data are huge for us to be able to see. And so, and I've requested, you know, when I received this and saw the same statistics, I said, okay, wow, I need to see this because, you know I still have the data that we had from DSHS, and, you know, and I have those reports, and I wanted to see how those were correlating. It has been a concern, the education level at which, you know, some institutions were running through their internship programs and the poor performance that some of them have had. And so, yeah, I completely share this concern, David, with you, in regards to these pass rates. And I'm making an assumption, and that's always dangerous, but that the majority of these numbers are reflecting individuals that are probably coming through internship programs, simply because with the exam waiver process of going through BOC first and then going through exam waiver, those people are not being reflected. So we're licensing a lot more people than these numbers are reflecting.
Right.
But this is becoming a glaring concern as to the education, and I think there's some, there may be some changes that we've got to look at in the future as to how best this gets managed. And I think it's going to be a situation that institutions are going to have to make a determination: are they in the education business, or are they just in healthcare delivery business? And those that share those can do both of those effectively. But if you can't do them both effectively, then you need to make that decision. And in all fairness to the student that's coming in, they need to know. They need to know what they're getting into and what the expectation level is. And so it's a major concern.
We've talked about this before, and it is, I think, at least part of our responsibility to educate kids that are in high school. Look, if you go to X institution, there's a 1 in 4 chance you're going to pass the exam.
Exactly.
That's a travesty for somebody to spend 3 or 4 years of their life not knowing that I'm not getting educated. So, I mean, when I see numbers like this, I
And
think
that's
tragic.
exactly what, and that's exactly why I requested that institutional data. And I want that published along with this, because people need to be able to see, it needs to be available. And I think, that's a concern of mine as well.
Fanny Pringle. I take your point, and I am in agreement. We anecdotally, that what you said is what we have heard as well, is that depending on the institution and whether they're going through an apprenticeship program, and that also is consistent with what we've seen in the other programs that I had spoke of earlier, that we're having some pass rate problems, issues as well. And so that is definitely on our agenda to get those statistics automated. I can, as we've said, as we've spoken before, I can get the information to you hopefully by Monday manually, but we are in the process of getting those statistics automated so that we can have those published and updated regularly on our webpage.
One other question I have, I hate to beat a dead horse. Is there a way that we can at some point, let's say you have institution X, and they consistently, we look at their history, and then we watch them in the future, and if they consistently underperform, I mean, their students, 28% or 22.9%, 19 of 64 failed. I mean, after how many years do we sanction them, or do we, at some point, I think it seems to me we have a responsibility to these kids to say, look, this institution, TDLR is sanctioning them because they're not educating these kids. I don't know if we have that power.
Let me comment on that. The board has never had there was 2 routes or there's 4 routes total, but primarily 2 being used to become licensed. And so the board and DSHS was never in the business of overseeing the institution. It was merely to evaluate the student, post completion of their education program. But yes, sir, I think, and I've had just some brief discussions with Mr. Francis in regards to, and as we came over from TDLR, one of the things that Ray mentioned is that they do have oversight over education programs in other programs that they oversee. And I think absolutely, I think this is something that's a glaring, obvious thing that we may come back to TDLR and say, okay, how could we implement an oversight program through TDLR to say, okay, this institution is an accredited institution or not, or sanction, that's a concern, a green, whatever we want to do, and so trying to bring in the national model, maybe in a partial portion, bring that into a state model and how that could be developed. Absolutely, I think that's a possibility, and I think that's discussions that can be had.
Fanny Pringle, good question. I don't know that TDLR has the authority as far as shutting down university courses or things like that. I know most of our industrial vocational programs that we oversee with the training providers, they're more individual. They're not. We have things there. We have high schools that are with and college programs, but I don't know what authority we have to close them. However, we do outreach, and I think that would be a discussion for executive, and that we would participate in and would definitely be involved in, to pursue whatever your.
No, don't misunderstand me. I'm not saying that you have a power to shut down a university.
Yeah.
No, I'm not stating that at all. But I'm stating that we need to look at what the powers are.
Sure.
Whether it's a rulemaking authority or a legislative effort on behalf of our board,
Sure.
or rulemaking authority on behalf of our board, or a legislative authority through the legislative efforts to better oversee. Because the bottom line, I think this board, we want a better product, a better educated student as a whole coming out of these institutions. We don't want to see these types of pass rates. Those are scary. Those are alarming rates. And if we have a judiciary authority to oversee some of these programs, to whether it's an accreditation or whatever that needs to be the terms used, from a state perspective, then I think that's what we may want to look at, and what the feasibility is of implementing, and how programs could be evaluated by you guys. At what level, of being able to come in and evaluate coursework, evaluate the clinical, expectancies and things like that, the clinical component of the student, athletic training student, whatever term you want to utilize, in these programs, to make sure that, to give them a better chance on the back end.
Sure.
Yeah, kind of the point I was trying to make is, I mean, if we look at a history, let's go back to institution X. If you look at their history and they have a failure rate in the 20s for 3 years, for the past 3 years, I mean, does TDLR have the authority to go to that institution and say, look, you suck? Just to cut to the chase. And
Dr. Schmidt?
No.
Yeah.
I don't, okay.
We don't, our general counsel is jumping out of her seat, but I'll let you.
Yeah, we don't have any authority, or we don't regulate the institutions and the schools. I understand what you're saying.
I'm not asking you to do anything to them.
Mm-hmm.
I'm asking you to go to them and say, you have a horrible pass rate, and you need to get some help. It's like a drunk. You need to get some help. And if you don't, we're going to publish it very, very clearly on our website that this institution has a horrible pass rate. Don't go there.
Go ahead.
Okay, we will not say it in those terms, but we will publicize those pass rates, fail rates, as we do now. We're trying to gather information as Fanny, and thank you, Fanny, for, I'm going to get Ray Pizarro for not being here, but the director of E&E. As we're trying to figure out what the problem is, we did understand that there would be a slight decrease in pass rate. It's a new test, so forth and so on. But I agree with you. This is not great at all. So we can't say you suck, but we can publish, as Fanny said, what programs gave us what numbers, and we can definitely, in some fashion, direct these students to the better programs. Because we are a state agency, we can't lobby either way for any specific program, but we can provide information. So yes, what we are looking towards is getting a good breadth of information out there so they can make good decisions. It's just that this one is new and for us, and we're working to get as many numbers as we can. We do have a couple of other programs that have issues, and it's a constant work group with questions. It's a constant evaluation by the E&E staff. So we're not happy either, but we have to kind of work within the confines that we have. But there are ways to get that information out there. You can say they suck, but we can't say they suck.
I believe you did.
I believe you did.
Institution X, you pretty well know.
Institution X. Don't go there.
And that's the thing that excited me about coming over to TDLR was the opportunity to maybe assist those programs. Sometimes you don't see the forest for the trees, and you miss the idea that you're not getting it done.
Yeah.
And that maybe, with the resources that TDLR has that is being provided to the athletic training profession, then maybe we can make some of these organizations, or these universities that aren't getting it done, to make them aware of it and maybe offer resources that will help them to improve their students' opportunities. And I agree, that needs to be published and let them know that you know, the monies that these students are paying out to get an education, it's coming in unfulfilled, obviously.
When we get, Mr. Gaines, thank you for your comment as well. When we get this information published, it's out there, it's public record. They can request it now because it is public information. It's just that we haven't gotten it into a format to post it because we would like a year's worth of data, correct, Fanny?
That's correct.
To have an accurate time period of posting. But if anyone wants it, it's a public information request, they can get it. Sometimes seeing something in black and white really helps a program. The universities, I'm sure, don't want a bad reputation. I'm not speaking for them, but I wouldn't want a bad reputation. So if it's out there in black and white that this just isn't helping this profession, your students are leaving with this much debt, this isn't helping them get a license, then that's going to help change things. We haven't yet had pushback from any education provider that I know of, and I'm getting agreement in the back from E&E staff. When they're presented with a problem, and they have typically worked with TDLR to help us fix the problem for our licensees. So we're just in the beginning kind of stages, but yes, we don't anticipate that they will push back. We anticipate once we have a clear set of numbers, hey folks, it's in black and white. You know, this
Okay.
is what it is, that we can get help.
Would it take, I don't know, what, if you need a board action, or if you need, the level that you need to generate a letter of concern to these, once we have this data, and I know, I'm pretty sure that the data is still available from DSHS, that we can go back, and if it's, as Dr. Smith used the example of Institution X, if Institution X was bad when we were with DSHS, and Institution X is now remaining to be bad with TDLR, what will it take? Do you need a board directive? Let's get a letter issued to that director of sports medicine at that institution, letting them know that there is a concern about their pass rates on the exam, and they're operating an internship program, or they're operating whatever type of education program there are, but there is a concern by TDLR, shared by the board, of their actions, and just basically a notice of concern.
Typically, if we need that, we could definitely move forward in some fashion. Typically, our director of E&E is boots on the ground. He calls directly, he goes directly there. He has staff that goes directly with him. He just had a flat tire, I believe, this morning. He wasn't here, but he travels extensively with assigned staff. And if we need a letter, we can definitely get a letter, but we just are more in your face than that, in a very polite way. So Ray will just contact them and have a meeting. And we haven't been rebuffed yet. So we just like to handle it mano a mano, or I don't know how to say it any other way. Woman on, I don't know.
Yeah.
But yeah, if we need a letter, definitely we will invoke the board. We definitely want your concerns to be heard. But we're trying to just handle it internally with E&E and executive examination and education, and reach out, and we go to the university. We go to whatever training. We go to that course provider, and we take a team to help them get better. That's what we've done with every other program, and I know we'll do with this one. But if you want some more insight, we can definitely loop you in with E&E, Presiding Officer Ware, so you can know exactly what they're doing to move this process forward. And I think it sounds like we want updates at this meeting, at our next one, and moving forward for how this is going to help this pass rate.
I'd like to make a
Sure.
motion. I'd like to make a motion that we evaluate the pass rates for the past 3 years and the current year, And if there are institutions that have a pass rate less than whatever number, 30%.
Okay, Dr. Schmidt, I'm sorry, I have to government us one more time. Because that is not on the agenda to make a motion, I know, blah, blah, but it's what we have to do. We are just having discussion, but we can put that on, as an agenda item for the next meeting. We just can't make a motion and take an action on something that's not noticed in the agenda. The discussion we're having, yes, but we will definitely have that on the next agenda. And we'll be working that in the meanwhile, as education already is.
Okay. I thought if it was an item that addressed an issue that was on the agenda, I thought that we could
Well, these
make
are just
motions
staff
based on that,
reports.
so.
Yeah, this Wendy Pell, Assistant General Counsel, this is a staff report from E&E, who's just giving you an update on stats. If you want to have a further discussion, I mean, taking action, I mean, obviously, it sounds like we want for future staff reports to include more detailed data as we are able to collect that and sort that. But as far as additional taking action on, or, you know, next steps and having further discussion about a staff report, we need to take that agenda and put that as an agenda item.
Okay, let's make sure that we try to phrase our meeting minutes and notices to where we can in the future, so that we can, you know, I think that it can be phrased, you guys know the right phrasing, but if it can be phrased in there that, you know, action can be taken based on reports.
Well,
you know.
and Wendy Pell, Assistant General Counsel, again, remember the part of this is public notice, so others will know to come. If right now we're noticing it's a staff report and it's statistics, they may not know all of a sudden now, based on the statistics, you're wanting to run new reports or reach out to universities or take action or, you know, sanctions against university. That's a whole nother agenda item, and that needs to be, the whole point is getting notice to the public so they can come and attend if that's what it is, and it's not staff report and it's statistics, and the next thing you know, a letter is being issued for, you know, based on the advisory board wanting to go sanction, or, you know, a letter of concern to a university. That's very different.
Right, I understand, I'm just trying, you know, our board meets, you know, once or twice a year, and, you know, it's, if we were meeting again in a month, it's not as critical, but it just handicaps, you know, it handicaps the board of being able to hear a report and then be able to adjust with it. So if that's what we've got to, you know,
Because
got to do.
I'm also aware,
but-
may
Sure.
I say, can we hopscotch just to make sure we are staying on target with the agenda? Because Dr. Smith, you are requesting a discussion item, a recommendation for the next board meeting. So I would like you to articulate that so we can get that specifically on the agenda for the next board meeting, if you would.
Okay.
Now, or when we?
Yes, please. If Mr. Ware will allow us to hopscotch to H.
As long as we can go back to the other
We
reports.
can go back.
Okay,
We can
yes,
go back.
we can move back, so we'll make based on discussion here of this report, we'll move to agenda item H, and I recognize the astute gentleman from San Antonio to make a recommendation.
That we discuss some type of enforcement action on universities whose pass rate is less than 30 or 40% consistently.
And I think earlier you said evaluation of.
The previous 3 years.
Okay, so we're requesting an evaluation, and I think E&E, I'm getting a nod from Fanny, evaluation of the previous 3 years,
Pass rates.
pass rates for across the board, or for universities, or,
Or anybody.
Across the board.
Just pass rates on the written
okay,
specifically.
okay,
And devise an action plan to notify those universities of their deficiencies in an effort to improve the education of athletic training
I like it.
students.
We can do that.
Very good.
Thank you, and this is Wendy Pell again. We're not trying to hinder your discussion or, you know, what you want to do. It's just that at this point, we can't do anything at this meeting, but we definitely want to recognize that and get that on the agenda for the next meeting so you can have a full discussion. So, we're
Okay.
definitely not wanting to cut off the discussion. We just need to have it at the appropriate time with the appropriate notice.
I understand, we just can't take an action on it.
And Dr.
Okay.
Schmidt, if you want to alter that, we have time. If you leave here and you're in the car, well, after you stop, and you want to call in and let Delia know, hey, I want to change it, edit it, or if you want to send an email, we can flesh it out, and anybody else who wants something else on that time, because I know this is kind of on the fly.
But let me just ask you a question. we have beat this horse to death, but we've made it clear to TDLR that we're very concerned about that. That doesn't prohibit y'all, but between now and our next meeting, of looking at some of these numbers and having Ray or somebody call these guys and say, I won't say that S word, but y'all aren't doing very well. And
You are correct.
We're concerned about, at our board meeting, we discussed the board's concern about that. So we don't have to wait 6 months before they, at least they,
Oh, no, and they're working on it now. Fanny specifically and Ray as well, and we'll continue to work. And I'm sure this will give Ray an extra kick in the patoot, I don't know. But we're already working on it. We too have those concerns, and your concern of the board just puts kind of the cherry on top. So definitely, we're not gonna wait for another meeting to get these numbers and making contact where we need it.
thank you very much.
Any other comments, concerns by board to Fanny before she sits down and, I know she's got some special things for Ray now, being he threw her under the bus this morning, and I hope she's wearing the bulletproof vest. She's certainly taken some shots, so, any other comments? Okay, thank you very much, I appreciate it.
Fanny Pringle, I'll have Ray call you in the interim to discuss options, what's possible, if that's okay.
Absolutely.
Okay.
Absolutely, thank
Thank
you.
you, Fanny.
Thank you.
Okay, moving into Enforcement Division.
Morning, Mr. Chairman and board members. I have the Hopscotch Athletic Trainer Advisory Board Staff Report for the Enforcement Division. You met in December, and in December you recommended to the commission that the commission adopt the penalty matrix for the athletic trainer program. The commission adopted your recommendation and implemented those penalty matrices. We've had that since January 27th. So on behalf of the Enforcement Division, I did want to say thank you to the board and also especially to the board members who participated in the work group to get that done. That's an immense help, and we appreciate that. The next thing we have is the enforcement case highlights. We had 3 cases in particular that were worthy of mention. 2 of those involved deferred adjudications in the criminal courts, and one of them was based just on a complaint, and we took action on that. I thought about this because this question has come up before with others. You may already be familiar, not with the criminal justice system necessarily by experience, but from reading reports and things like that, with deferred adjudications and that kind of disposition. If you're not, I'd be glad to give you a refresher on it or just an orientation on it. But if you're fine, you're good on deferred adjudications, we'll move on.
Do we need to?
I'll take an education.
Go ahead.
Okay.
For $100? Sorry, we're not playing Jeopardy, are we?
Well, we hopscotch past that $100. We're back to free stuff now. Deferred adjudications, this is a type of court disposition in criminal court. You got convictions. Everybody's familiar with those. Person goes in, pleads guilty, or convicted at a trial. That's a conviction. You are guilty, you'll pay a fine or go to jail, one of those 2. A deferred adjudication is a little bit different. It's a gift to the defendant. The defendant goes in and pleads guilty or no contest or nolo contendere if you went to a private law school. Anyway, they plead guilty essentially and say, okay, fine, I'm not going to have a trial. And the court says, all right, well, we'll defer the adjudication on this. I'm not going to pronounce you guilty. I'm not going to convict you today. We'll put you on probation, which they now call community supervision. We're going to put you on community supervision for a while. If you do well, you follow all our rules, then at the end of this term of community supervision, we'll dismiss it. And you won't have this on your record. That's all well and good. Like I said, it's a gift for defendants. For our purposes in the licensing, we can consider those deferred adjudications when we consider a person's criminal history to determine whether their background renders them ineligible for a license. In the two of these three cases, like I said, we have deferred adjudications, and it's, all three of these are for inappropriate sexual conduct, as you probably are aware if you read those little highlights there. So anyway, that's deferred adjudications, and we have two of those. The first one is kind of interesting too because it combines a deferred adjudication with a revocation. The person did not comply with all of the conditions of probation, and the court revoked that community supervision, found him guilty, and sentenced him to prison. Well, this brings into play another concept in the criminal history evaluation world, and that's in the Occupations Code, a revocation by operation of law. This person had an athletic trainer license, but the minute he stepped into prison because of that felony conviction, it was automatically revoked. His athletic trainer license was automatically revoked. We didn't have to do anything. We did send him a letter whenever we found out about it, but other than that, that was it. You go to prison for a felony, your license is revoked, period. The second case involved, this was the complaint case that we had. The athletic trainer at this junior high school became involved in some inappropriate, or engaged in some inappropriate sexual conduct with some of the kids there, including a 14-year-old girl with some inappropriate touching and so forth. We notified him of the complaints. We told him we intended to revoke his license because of it. We never heard back from him. And so it was a default order that was issued. The executive director issued the default order, and he was done. His license was revoked by that process. The last case on this list involved a licensee who provided athletic services or athletic training services to a high school football team. And she went a little bit further and became sexually involved with one of the football players. This was another one of those deferred adjudications, and certainly this is one that we used, even though it wasn't a conviction. We used it and said, you know what, we're going to revoke your license because of this. And she agreed to this one, and so we had an agreed order that disposed of that case. Do y'all have any questions on any of those or any of the things that went on there?
Any questions, board?
Are these taken on a case-by-case basis? Obviously, there are different levels of felony convictions, misdemeanor convictions. And I ask that because I deal with this daily situation for sports officials. So I'm just kind of curious on how y'all look at these.
Well, we had the we had the criminal conviction guidelines. The criminal conviction guidelines tell us what the commission says. You know, if somebody's got this kind of conviction, we really don't want it licensed. But we also have the Occupations Code that says if you look at a case and it's really old, then maybe you don't want to think about denying that person license. I'll just give it to them. They've been real good since then. They've upheld all of their responsibilities and probably give them a license. So yes, it is on a case-by-case basis. But I will tell you that it's we view it very seriously under circumstances like these when people use a position of authority and trust and impose their will on people who are more or less subjected to that authority, such as these sexual cases. We take a really dim view of those kind of cases.
My concern with the deferred adjudication aspect of it, and that's why I wanted you to go over it, was the case is brought forward, it's given deferred adjudication, and therefore there's no guilt or innocence determined at that point in time. Yet, if there was guilt involved, if there was guilt declared, our issues would be that, okay, because you're found guilty, your license is revoked, but they go through a deferred adjudication setup, and they complete it all and don't necessarily get the guilty verdict. Where does that stand with our licensure? Maybe because they don't get a criminal record, do we still want them with a license?
That's why the law allows us to use those deferred adjudications and treat them as convictions for the purpose of determining whether a person should have a license. I agree with you wholeheartedly, and so did the legislature.
Mr. Gaines, I think maybe I can comment, is TDLR will perform their own investigation and that being brought into evidence. And, you know, again, TDLR can make a decision on revoking a license or allowing a person based on their investigation and their information, and which the case can be brought even into them to where the individual could have to testify in regards to their situation and determined by, by the review here to determine whether a person could keep a license. So they can act independently of the criminal system.
Right.
And so there's avenues to be able to act independently, that we're not completely bound by the court system.
And that was my concern. I just,
Correct.
I mean, don't want to fall back because we act, or TDLR acts independently of what the courts determine and then the final adjudication of it. And then they come back and say, well, I didn't get convicted, or I didn't get found guilty, so how can you revoke my license?
And there's some, and we've had, Dr. Smith and I have had cases which we were at DSHS that, it didn't meet the level of a criminal conviction. But, it's, the level of evidence, the preponderance of the evidence in a criminal case is different from a civil case.
Mm-hmm.
And in regard, so I have attended a jury duty education before. So, so the level of proof that is needed by TDLR to sanction an individual can be at a different level than is required in the criminal justice system.
I'd rather us take our chances and revoke their license, and if they want to come back at us,
Oh, I
that's
agree.
fine. But our penalty matrix is pretty straightforward. And the fact that a court put somebody under community supervision at least means to me that you're probably not the nicest person around, so let's take your license away. And if they want to reapply later, what's our situation there? Like, let's say this Cassie person does her 5 years of community service. She decides 7 years from now she wants to go back and practice athletic training. Can she reapply for a license?
She can. Among the factors we're required to look at, as well as the courts whenever we go through the hearings on these things, the length of time since the offense occurred. So if it was 7 years ago, that's starting to be a pretty good length of time. What was the person's conduct like in the intervening period? Now, she's been on community supervision. We kind of are wary about that period when they're on community supervision because they really don't have a choice. They have to toe the line or they're going to prison, and they know that. What we're really interested in is what happened after they got off of community supervision. Were they really good then? Did they fulfill all their responsibilities? Were they not commit any violations? All of the things, there's a whole list of factors in there. How do they treat people? All kinds of stuff. That's what we're really concerned with, is when they're not under some kind of legal compulsion to behave properly, how do they behave? The courts are mixed on, the administrative law judges rather, they're kind of mixed on whether they should consider their behavior while on community supervision or just wait until they're off of community supervision. And again, it's on a case-by-case basis. We have to look at all of these things, the individual, the circumstances. How many other criminal violations did the person commit? That's a big factor in those too. With these, I think I mentioned that with these sexual cases, we take a really dim view of those. And to us, the number of other criminal cases means a whole lot less when you've got these kind of cases where they're taking advantage of high school and junior high school kids. But if it's something, and I just for example get into another program where you have an electrician he's committed 6 DWIs. Put aside for the moment that you may not want this guy wiring your house, but that's not in the criminal conviction guidelines, and if you go through the analysis that's in Chapter 53 of the Occupations Code, you'll find that it's not, the conclusion will be that it's not directly related to the occupation of being an electrician. So that, you can have an extensive record of that kind of stuff, and it won't affect your licensure. Take that same electrician, and now you've got him harming children or being taking advantage of them, sexual exploitative behavior. Okay, that's a different story. We may not care about the DWIs, but we've got that one there. We don't want this person going in people's houses. Well, the same is true for the athletic trainers. We don't want them around kids if they're showing a propensity to engage in that kind of behavior. So we look at all of those factors and determine what is the likelihood that this person will again do that.
And I think you have to also consider being very conservative in that situation, because you've taken, in most of those cases, you've taken the person out of the environment at which they committed their offense. And, and maybe they've been appropriate, but they haven't been in the environment of risk, in the environment of being exposed to those possible situations in that window. Does that make sense? You've taken them out of their employment setting where they committed their offense, and, for a great period of time. Whereas that same example that you gave me of, as far as the DWI, the electrician, you haven't taken him necessarily out of the environment of having to make those correct choices. He's still in society.
That's right. It makes me think you maybe read this statute before. There are two considerations, especially with deferred adjudications. Is it possible, it's the statutory language, is it possible the person will continue to pose a threat to public safety? Okay, is it possible? The second consideration, will employment of this person in that position provide the person with an opportunity, not will he do it, but will it provide him with an opportunity to repeat the conduct that, of course, he lost his license for in the first place? So those are two important considerations.
Right.
And we do. We do, and the courts do. That's a starting point, actually, with deferred adjudications.
Any other parts of your report, or can I call for questions?
We just got through the highlights of those cases, those 3 cases. We still got the key statistics.
Okay. Any questions on those cases, I guess, or we'll move forward to...
I'm sorry, I got one more. If someone is under supervision, community supervision, it's still possible for them to have an athletic training license?
It is, but I think most of the time, if not all the time, if it's for one of these cases kind of like these, I don't think so.
Not automatic, but it's in your purview to suspend the license.
Right. It will, well, revoke. We wouldn't even suspend it. We would just plain revoke it, say you just can't have one. Not under these circumstances. This is very important, and we recognize how important this is. It's society does as a whole, and that's why we have the statutes and the regulations developed the way they did, and of course our attitude toward these things, and then public safety. After all, that's what our concentration is. Public safety, public threat to the public, harm, those kind of things. That's what we want to concentrate our efforts on. And so when we get cases like this, we jump in wholeheartedly.
Okay. Anything else, and we'll go through their statistics here? Okay, go ahead and continue on.
Okay, well, we have the key statistics next, none of which I'm going to read to you. But I will kind of explain a little bit about how we got there. We just talked about 3 cases that were resolved after there was a notice of violation and a revocation. Some cases are resolved by dismissal. This is typically when we do not have sufficient evidence, or maybe don't have any evidence at all, of a violation. Some people will complain about something because they think it's unseemly, but it's not a violation. Some cases we dismiss because we have conflicting evidence. We're unable to reconcile it. He says one thing, she says another thing, and we don't know who's right, and we don't have any way to figure it out, so we just have to let it go because we can't prove anything. Just one quick example, we recently had a case where an athletic trainer was alleged to have improperly failed to recognize a concussion at a junior high school football game, allowed other students and other persons to call her doc, and then questioned a diagnosis or some advice given by a doctor and suggested the possibility of going to get a second opinion or maybe even seeing a specialist. Well, none of those things, with the possible exception of the failure to recognize a concussion at a football game. But in that case, we couldn't find any one protocol that says this is what you do and you do it every time. And even the evidence there suggested that there wasn't really any reason to believe this person might have suffered a concussion in that case. Okay, that one's put aside. Doc, we know, we put that one aside. We go on to the last one there. Challenged the wisdom of a physician? Well, she didn't really say the person was wrong and, I don't know. Anyway, it wasn't a violation. You can tell anybody you want. Maybe you ought to seek a second opinion. Maybe you ought to see a specialist. That's not a violation of our statutes and rules. A lot of stuff there, but no violations, so cases like that we dismiss, and we dismiss that one as well. Sometimes we issue warnings. This is when it appears that a violation has been committed, but remember when I spoke about we want to concentrate our efforts and our resources on things that relate to public safety, to threat of harm to the public. If it's not at that level, then there's a good chance that we may just resolve that case with a warning. We've had a few cases, for example, where we've had personal trainers or coaching assistants who've been characterized as athletic trainers on an organization's website by a third party and ostensibly with good intention, somebody who just didn't know. We could contact those people, and we did, in fact, in the cases that we had. We contacted those people and we told them what the violation was, and they said, holy cow, I didn't put that up there, but I'll make sure it gets down. And they did, and all was resolved, and there wasn't any harm to anyone, so we just issued a warning on it and went on our way. It was sufficient and it was appropriate. I think that pretty well wraps up how we resolved those our cases, and maybe explains a little bit about how we got to those numbers, but if you have any questions on that, or how we ended up with the numbers that are shown, I'd be glad to answer those.
Any questions, comments, board?
I do have one question. So if somebody has, if somebody contacts one of us and says there's somebody within my school district that is working as an athletic trainer, and they don't have their license, or their license was null and void, back in 2010 or whatever, they need to contact you?
Our intake division our intake section in the enforcement division,
Okay.
If they call that TDLR, file a complaint number, 1-800,
Okay.
Whatever it is. They can file a complaint over the phone. I think they can do it by email maybe. There's a number of different ways they can do it.
Okay.
But yes, if they'll contact us, that will initiate the complaint process. We'll open a complaint. We'll investigate to determine, was there a violation? And do we have the evidence to prove it? I'll tell you right now, I am working a case that that very allegation has been made. The difficult thing is finding the evidence to prove it. Because we can have people say, well, I saw this guy. He was out on the field with the coach, and the student was injured. What was he doing? Well, he was being an athletic trainer. Well, what was he doing? Well, he was, and so you get that. And for someone to say, well, I just know it, of course, is not sufficient evidence. We have to know exactly what they were doing, or we have to know exactly how they represented themselves, and we have to have evidence that we can bring to a court to show the judge those things. Because if we don't have that, then there's really nothing we can do. That's a stumbling block that we run into quite a bit, is people who just know something's going on there, but they can't prove it.
Okay. Thank you.
Sure.
Anything else? Okay, thank you, sir.
Thank you.
Appreciate it. Okay, I think our last report is from our licensing division.
Good morning, members. Mr. Chairman Weir, Leonard Rivas with the licensing division. Just to give you an overview, the licensing division is heavily involved in phase 2 implementation for the programs being transferred from DSHS. We're also heavily involved with the transfer of the podiatry board that will be here September 1st. We're also on the Versa improvement team, and the other thing is you have a licensing report in front of you. It's different than what I provided to you in the past, so I'll go over the report quickly with you. So for the first quarter, those include October through November. It would have included September, but since we didn't transfer into October, so it's October through November. And then the second quarter is December through February, and the third quarter is March through May. And you can see the number of new licenses we've issued for each of those quarters, the renewals, the online renewals, the percentages of online renewals, and the total population for each of those quarters. At the bottom, the same thing. First quarter is October through November, second quarter December through February, and then March through April.
So does the 3651 mean, that's the number of licensed athletic trainers?
Correct, for
in
the
state
third
of
quarter.
Texas?
Yes, sir.
Thank you.
The other thing I need to inform the advisory board about is Chairman Weir contacted our office. We issued a license to someone under the exam waiver that was ineligible for that license. So we contacted the individual. They're set up to take the exam and go through that process. We also did an audit for all applications issued under the exam waiver from October through current, and we did find 2 additional individuals that were ineligible for the exam waiver. We've contacted those individuals as well. As I discussed with Chairman Weir, we did update the checklist to include the effective date. That way, when a staff member is processing that exam waiver, if it's not after January 1st, they don't qualify for the exam waiver. That's all I have at this time, unless you have questions for me.
Any other questions, comments from board? Okay,
No?
thank you very
Okay,
much.
Thank you.
I think it concludes our reports section. I know we've already had some brief conversation in regards to 4007, but is there addition? We have an agenda item F. Is there anything that needs to be added in that?
Mr. Chairman, I included that in the executive statement.
That's what I thought. Okay, so we've effectively taken care of F.
Yes, sir.
Okay. Section G, discussion recommendation for issuance of an honorary certificate of recognition by the department. Let me give you a little bit of background. I shared an email with board. I've got several other copies if you guys, anybody else needs them. I can pass that to you guys. I just need one here that I can work from, and then I have 4 copies, so when it needs to make further. Basically, I was notified of a tragic event from a license holder was an athletic trainer at Navarro College. And he contacted me that one of his students, and that particular license holder was Mr. Nate Yost. And Nate notified me that he had 2 student athletic trainers that were involved in an automobile accident. And one of the young ladies was actually killed and died from the wreck on March 19th of 2017. She was, in his student athletic training program, had planned on pursuing athletic training as a career. And his question to me was, is there any authority, is there any way that this individual or her family could be given an honorary license, honorary certificate, just because of this young lady's desire? He indicated, and you can read through the item there as far as some of the things, qualities that he stated about her. I said, well, and to my knowledge, there wasn't any rule authority to issue an honorary license to an individual that is deceased in regards to that. I said, but I certainly will bring that to the board and bring that to TDLR for consideration. I think this would be just a certificate or something to be given to the family in honor of this young lady and in that situation. I want to make it clear, she was not a licensed athletic trainer at the time. She was a college student pursuing an athletic training education and pursuing an athletic training license eventually, as we understand what her intentions were. So that's basically kind of the background. So I kind of open it up to the board and determine if that's something that we would like to take a special dispensation or special recognition and be able to do this, or if we have the authority to be able to do this, or is it a situation that it's not warranted, it's not appropriate, it's not something that that TDLR would like to do, or not that they would like to do, that's not the right term, but efficiently can do, can legally do. So I guess I throw that, first of all, with the next question is you guys being able to even tell us that this is something that could be done, and then we could discuss it as a board of decision, or is it the next step of discussing as a board and then asking you, could we? So.
Mary Winston, I'll start. Definitely, the way that it's been placed on the agenda and the way that you worded it is completely appropriate. Because it's an honorary certificate of recognition, based on the communication and the untimely death of this young woman. The department, it would come issued from the department, but this is at the behest of the board. If it's something that you would like the department to do, we would follow your instruction to get this document and contact the family if they'd like to come. We've done this in the past, and if we can, we like the family to come and to accept this on behalf of their loved one. So if that's something that you want the department to do, we can do that.
Okay, well, we'll shift it, then I'll shift it to the board, and any discussion, thoughts you guys have in regards to this? I had not shared this because of the open records and things. I did not bring it to you guys until today. Do you guys, any initial thoughts?
Absolutely do it.
Okay.
I like his statement in the email down at the bottom. I like everything that he has given us. My vote would be to do it and bring the family up here, and I think that would mean a lot to them.
Okay.
And have the tissues ready for me.
Any other comments, or now, then we can actually, I'll ask for a motion so that we can officially do that. I wanted to have any discussion before I called for a motion or concern that if we need to phrase our motion a certain way, so.
I want to make the motion.
Okay,
I'll second.
okay, motion's made by Dr. Smith, seconded by Brittany, that we formulate an honorary certificate on behalf of Kayla Simple, and present that to her family. We would like to invite them to this and award that. Any other discussion? All those in favor indicate it by saying aye.
Aye.
That passes unanimously, and so we would like to make that. If you, I think Mr. Yost indicated he was hopefully going to watch this and stream it. He is taking a new job at University of Mississippi. And so because I invited him to come today to actually present to the board and he said he would love to, but he's a new employment. So I do still have his contact information, and so I can get that and get the direct contact information of the family.
That would be
And be able
great,
to share
great.
that with you guys so that we could, have that process, started. And if they're unable to attend, I will certainly try to make, we can schedule accordingly, and I'll be happy to go to, if we want to go to their high school or something like that and present that, I'll be happy to do that on behalf of the board. If they're unable to travel to Austin or make our next meeting.
And we will still, that would be great, and we will still, at least for the record, for the next meeting, we'll have the official certificate honoring her, so it can be at least seen by the family at that time.
Okay, thank you very much. Any other items we've added one item as far as on section H. It's opened up more to communication and board action regarding our exam and results of that. Is there any other agenda items that you have? Well, obviously, that remains an open question, and so once you're notified of our next meeting date and time, you certainly, as I did with item G, you certainly can mention that so that it can be placed on the agenda. So if something comes up in that meantime, it doesn't, that opportunity to add to the agenda doesn't stop today, so.
And Chairman, this is Wendy Pello. Just one thing just to add from the staff, that we will have proposed rules for your next meeting in terms of implementing House Bill 4007 as well. So add that to your agenda.
Okay.
And just for my education, any agenda item has to be presented at least 30 days before the meeting, is that correct? Or how many days before the meeting?
No, we'll have to publish the notice of the meeting. It's at least 7 days prior to the meeting, not counting the day of the meeting or the day it's posted. But if you can get that, your agenda items to Delia, I'm sorry, as soon as possible, but yeah, it doesn't need to be 30 days.
Okay.
But it'll have to be there so we can get it posted and the notice for the meeting posted appropriately.
Okay. Any other items? Based on that and the need to do that, when are you guys thinking that we'll need to, I know our last meeting was December. Initially, when we came over, we were meeting almost quarterly. When we've kind of moved to, twice a year. Is there, based on 407, when do you anticipate us needing to come back together?
We have a bill implementation timeline and for the athletic trainers. rules. We have it scheduled, maybe coming back the week of February 12th through the 16th for the first time to talk about the proposed rules, discuss them, and then recommend publication in the Texas Register. And then with a follow-up meeting, a second meeting being the week of April 30th through May 4th. And that was come back and discuss the public comments we received during the public comment period, and then hopefully propose or recommend adoption of the rules and that recommendation going to the commission for them to adopt. So.
Okay, based on scheduling and spring sports and things, is there a way that we could move that? Could we have that meeting instead of the February meeting? Could we back that into December or an early January meeting, if possible, or not?
Probably.
Okay, according to our general counsel, that is enough time for her because she's the drafter of the rules. And now we're gonna go to Delia to see what the schedule looks like. December or January?
Yeah, if we get, something like that. I mean, kind of about the same time frame that we had our last December meeting, before obviously we get into Christmas holidays, but, try to get out of the February.
Personally, I prefer a January.
Okay?
Early January would
Could be like first week of January?
Second.
Second.
Talk about early.
Yeah, I can't do the second week.
We're getting it quick.
Do we have that open, Delia, or are we booked?
Oh, January the 2nd, okay. I thought you said second week of January.
January 10th.
January 10th or January 17th, and I'm trying to keep it up on a Wednesday, like,
Okay. See, I think, I think the 10th would probably,
Wednesday's not gonna be a very good day for me, because I'll have games on Tuesday nights and won't be able to get here unless I leave early.
Thursday the 11th?
how was that be potential?
That's better.
Okay, so
I'm
let's,
good.
let's
I'm
go
good with the
potential,
11th.
let's go potential January the 11th.
You'd rather do a midweek versus going back to the Mondays like we had before?
Me? All of us?
Just a,
Doesn't, either way.
And at 9 a.m.? Is that still good?
9's fine.
Yes.
You want to do Monday?
Would Monday work?
Well, that's what I was,
Would January the 8th work?
Or 15th? January 8th?
January 8th?
Monday, January 8th?
Yes.
Is that better
That
for you
works
to
better.
travel?
Okay.
Okay. So we'll plan on January the 8th then.
Gosh, almighty, 2018.
Mm-hmm.
Oh, my word.
Okay, we have the date, the time, the location. Any other items of concern that needs to be brought before we call for adjournment?
Go ahead and do
Chairman
the,
Ware,
Yes.
would you like to schedule that next one since we were planning on, Wendy read off, the week of April 30th through May 4th. Is that going to?
Just let me
pose
look
a
at
problem?
that one.
They've backed everything
And
up
actually, we
almost.
can back it up, hold on.
Yeah, because they moved like the February to January, so if you move April, it's probably to the March. We just need to leave enough time for publication, have public comment period, all that.
So we can actually look at March, look at the March calendar, Del?
Don't look at March.
Don't look at March.
Don't look at March. Okay.
March is the athletic trainers' worst, nearly almost next to the old two-a-days,
Oh,
which we
okay.
don't have anymore.
It's gonna be, I guess, or the same day. You want April? Because March is just.
So end of April would be feasible.
Okay,
Oh,
well,
so
we're
keep-
still there.
so
like the
Keep it there.
23rd?
Keep it there. Oh, let's see, 23rd.
23rd or 30th?
Either one.
30th, out for Mr. Fitch.
April 23rd is available, Monday.
Is that
April 23rd is fine for me.
Mr. Gaines?
That's a long way ahead, but yeah.
Okay, so let's go tentative, and we can rediscuss that again
Yes.
at our
NBA
next
playoff-
meeting, so.
NBA playoffs will be going on, so.
Wait a minute,
depending
wait a
if
minute.
We're on the road or not.
Okay,
We shouldn't be on the road the first round.
okay. So we'll tentatively set that as April 23rd for that meeting, and discuss it again in the January meeting. Okay, any other items for consideration? Okay, we are adjourned. Thank you.